Hello, and welcome to week 3. This week we are going to be getting into chapters 7 and 8 in your textbook. Chapter 7 talks a little bit about police reforms and legislative changes, and chapter 8 talks a lot about the rights that are afforded us through the Bill of Rights. Talks about the right to be free from unreasonable searches and seizures through the Fourth Amendment, talks about the Miranda rights that stem from the Fifth Amendment and the Miranda case that necessitated law enforcement in certain circumstances to advise folks of those rights. But what I want to talk to you about today is backing up a little bit, backing up to the Fourth Amendment, the right that we are free uh, as members of this society, as part of the American criminal justice system, we are free from unreasonable searches and seizures according to the Fourth Amendment, which is to say, we're not free from all searches and seizures. The government does have a right to seize our person, to seize our effects and our papers, but under certain circumstances that are deemed to be reasonable or under reasonable circumstances. We're going to talk about what those reasonable exceptions to our privacy are. What I can do, what I like to do when I talk about the subject in class, and I'll do it here even via video lecture. If you want to take a piece of paper and just write the word spice for me, SPICE, and that is how I think the easiest way to remember the exceptions to the Fourth Amendment are spice. I call it the spice chart or the spice exceptions, and that's just an acronym that helps folks remember the exceptions. So the first one we're talking about is the S in SPICE, and that is search warrants. Obviously, if a magistrate, an unbiased magistrate, signs a search warrant, then we have to submit to a seizure or a search of whatever is listed in that search warrant. It could be our person, it could be our home, it could be our property, it could be any number of things. So a search warrant is obviously going to be maybe the most famous way that the government can lawfully violate what would otherwise be our right to be free from unreasonable searches and seizures. Search warrant. The next one is P, and I want to be very specific here. It's P for probable cause, but it's not merely probable cause. It is a probable cause exception for vehicles. The probable cause exception for vehicles. That is P. And that is saying essentially that the government is not required, when I say the government, law enforcement officials, the representatives of our government, are not required to necessarily obtain a search warrant in order to search our vehicles. Case law has explained and set precedent saying that essentially if the government were required to leave and go get a search warrant and come back and search our vehicle or any vehicle, what are the chances that vehicle is going to still be there when they get back? So, with that in mind, case law precedent has been set that says, you know what, if there's enough probable cause that would allow a police officer or a law enforcement officer to go get a search warrant, then they can skip that step of getting the search warrant for vehicles only. Now, if we're talking about houses, that house isn't going anywhere. Still need to go get a search warrant. But for a vehicle that is able to be moved, there is a probable cause exemption for vehicles. Now, if that vehicle cannot be moved, now we're talking about if a police officer believes that there is enough probable cause to believe there's contraband or evidence in a vehicle, and that vehicle has no engine and no tires and is up on blocks, it's not going anywhere. So that P, the probable cause exemption for search warrants, doesn't necessarily apply. Let's talk about the I in SPICE. Incident to arrest. Just a fancy way of saying uh, with an arrest or because of an arrest or after an arrest. Incident to arrest. Uh, just saying essentially that if somebody is placed under arrest, under custodial arrest, and they're being taken to jail, the government has an opportunity, has a right to search that person and the area around that person, the wingspan around that person, and allows them to look for contraband or evidence. And one of the primary reasons for that is because we don't want folks bringing contraband or evidence into jails. So the I, incident to arrest. The next one, I know we're kind of breezing through these, but the next one is C, consent. Now, the main thing to keep in mind about consent is that consent trumps everything. There doesn't necessarily need to be any other suspicion or hunch or anything. In general, a law enforcement officer can ask you or ask me or ask anyone without any other suspicion, hey, do you mind if I search your car? Do you mind if I search your person? Do you mind if I search your house? Do you mind if I search your property? Do you mind if I search your lunchbox? Anything. And if you or I decide that we want to give consent to be searched, there's no other threshold of evidentiary suspicion necessary. Now, the thing to remember about consent can also be withdrawn, and consent can be limited. You can, one could say, sure, you can search my car. You can't search the glove box, though. It's consent. As long as there's no other probable cause or search warrants involved, we have the right to be free from unreasonable searches and seizures. And if there's no probable cause, then we don't have to we don't have to submit consent, or we can limit the consent, or we can withdraw consent. Three key issues when it comes to consent. And when consent is given, there's no other proof that needs to be provided once we go to court for that case. Merely having consent. Now, one can argue I didn't give consent or the consent was under duress. There's a litany of things that could be argued in court and could be mitigated through body camera footage or signed consent forms and the like. The next one I want to talk about is the E in SPICE, and that is exigent circumstances. Some folks call this emergency circumstances. Both start with an E. Just technically, the legal term being exigent circumstances, being that when an emergency is occurring, the government doesn't have to get consent or have probable cause or go get a search warrant if there's a fire in somebody's house or somebody's being stabbed and the police officer can see that happening. They don't have to say, there's probable cause, but there's no probable cause exemption for houses. I have to go get a search warrant. I do have evidence. My body camera is showing them stabbing somebody in their house. Let me go take that body camera footage to a judge and get a search warrant. No, the government's not required to do that. There's an emergency. They're going in to act on that emergency alone. Now, the thing to keep in mind about the E, the exigent circumstances exception, is that they are not entering somebody's structure, somebody's residence to obtain evidence. They're there to address the exigency. They're there to address the emergent situation, the emergency. And then once that emergency is quelled or is taken care of, now there's a couple things that can happen. Now, either the area is secure and a search warrant needs to go get be obtained, or if there's evidence that is in plain view, the plain view doctrine would allow the government to seize that evidence alone, but not necessarily go searching for other evidence. Again, search warrant may still be necessary, uh, or if no evidence is found and the exigent circumstance is taken care of, then no further investigation may be necessary. But those are the five primary exemptions to the Fourth Amendment that I wanted to talk about today. The SPICE chart: search warrant, probable cause, incident to arrest, consent, and exigent circumstances. There's a couple other that I usually throw in there. Parole probation is another exemption to being free from unreasonable searches and seizures. Those who agree to be on probation or agree to be on parole may give up their right to be free from unreasonable searches and seizures based on the conditions of their parole or their probation, which may often allow the representatives of the government, the law enforcement officers, to search somebody. Somebody may be required to submit to a search of their person and effects and property at any time during the day or night, with or without a search warrant or probable cause, merely based on the fact that they are on parole or on probation. And then the other one that your book talks about is uh, the pat downs, Terry frisks, stop and frisk. The idea that the government at times can pat somebody down, but merely for and solely for weapons. The idea that when a police officer stops and talks to somebody who's armed or dangerous, and they have a reasonable suspicion to believe that somebody is armed or dangerous, that law enforcement officer has an opportunity to pat them down, a check of their exterior clothing, just to make sure that the person they're talking to doesn't have any weapons, so that they can continue that conversation. Now, a pat down is not a search for evidence. There are some exceptions to that may allow if a law enforcement officer feels and immediately recognizes contraband, they can act on that. But in general, they're merely looking for and solely looking for weapons in those occasions where Terry v. Ohio laid out the reasonable suspicion threshold that the law enforcement officer believes that the person that they already have legally stopped may be armed or dangerous. And the key to remember there is that they're already legally stopped. The idea of these stop and frisks occurring, the lawfulness of a stop and frisk would not be in effect if the law enforcement officer were to jump out of the car, stop somebody for no apparent, no lawful reason, and then decide they're going to pat them down. There has to be a lawful stop first. It's a stop and a frisk. It's not all in one. So there has to be reasonable suspicion or probable cause for the stop. And then there has to be separate reasonable suspicion to believe they may be armed or dangerous. Those are the keys to remember when it comes to a Terry frisk, a pat down, a stop and frisk. All those are synonymous. They're all essentially the same thing, all stemming from the Terry v. Ohio case. So with all those in mind, make sure we look forward to this week and the assignments that are due. Check our due dates, and I should have your assignments from this week graded in the next few days. As always, if you have any questions, please reach out to me, and we will make any accommodations that we can.